Okay, thanks for joining. So, like I said, today I will be talking about the favorite form of all, the Agency Law Pamphlet. And this form, it is one of those things where we always have to have it. We probably don't explain it very well, and it's just one of those sort of requirements to have done. But there are reasons for this. So in today's class, I'm going to be covering why we use this disclosure. What are the requirements for us to actually hand it out? Like, when are we supposed to be doing this? What are the duties that we have in our representation? When do we give this pamphlet? What circumstances do we need to provide this pamphlet? And who do we represent in certain situations? All of this is going to get us ready for 2024. So by the end of this class, I hope that you are also ready for what's coming up. So why do we disclose? If we think about this, let's think about a situation where we might be showing a home to a new buyer. A new buyer has no representation right now, and they probably don't understand how our industry works. So it's important for us to disclose who we represent. In a situation where we don't own the listing, that means we don't represent the seller. And there are certain agency duties that we have when we do represent somebody, and others that we have when we do not represent somebody. We'll want to think about this when we're showing another agent's listing, if we're showing another agent's client to a home, if we're holding an open house for another broker, if we're just being a showing agent, maybe sitting at an open house for your own listing and having a buyer walk in, or meeting a potential seller at a listing appointment. All of these situations put us into a different window when it comes to who we represent and those duties that we have for that person. So when are we going to give this? Technically, we do need to give this agency pamphlet anytime we are providing real estate brokerage services. So that definition in itself is a very, very broad spectrum of things. What are some of those things? I've just listed out a few of the things that could be considered real estate brokerage services. There are probably more than this that I didn't think of. But anytime you are talking to somebody about a listing, you are providing real estate brokerage services. If you open up a door for another agent, there's no way you cannot be providing real estate brokerage services. Showing a home, providing a CMA even. If you're giving somebody a price opinion or you are advising them in your role on the market or anything that has to do with their home value, you are still doing real estate brokerage services. Holding an open house, listing appointments. Obviously, anytime you're going to be negotiating a contract or writing anything up, that is definitely those services. Thinking beyond that, though, what about providing home searches or soliciting yourself in marketing or advertising? Anytime you talk to somebody about real estate, you could be putting yourself in a position where you are providing these services. And those services would require that you give the agency law pamphlet and disclose any representation you have. So our new pamphlet has been actually kind of simplified. Thank goodness, because we went from having these terrible definitions with tons of legalese, nobody's understanding them, not even the brokers explaining them, to a really, really nice 4-page document that just bullet points everything very plainly. So I've just cut and pasted a few things from the agency law pamphlet. We need to remember that we are overseen by the Washington State Department of Licensing. And that Department of Licensing has rules and regulations that we have to follow in order to keep our license and be in compliance with our license. One of those things is you have to work under the supervision of a broker. So that would be in our situation, you work for part of the Madrona group that is overseen by the broker Joe is the broker who oversees. Each of the offices can have either a branch manager or they can have a managing broker who then supervises brokers, can answer questions about contracts. But that's kind of the stack of how the Washington State Department of Licensing oversees and enforces the rules that are in our industry. If you have questions about who you need to directly contact, depending on your location or whatever situation you're in, please feel free to reach out, because anybody with a managing broker's license can actually help in, guiding you to an answer. Okay, so we are going to be required in 2024 to create an agency relationship. Up until then, we always had this idea of this assumed relationship, at least with buyers. We've always had to have a listing agreement with a seller. So when we talk about creating an agency relationship, what does that mean? It just means we need to enter into what they're calling a written service agreement. For sellers, it's going to be the listing agreement. For buyers, it's going to be the buyer-broker agreement. But either way, we're going to have something in place that proves our relationship rather than just assumes it. We will also have the option of discussing dual agency with our clients, and come 2024, they can actually say no to you becoming a dual agent. So think about how we're going to be explaining what that means. The dual agency that they can object to is by you as their agent representing a buyer and a seller in your transaction. Now, keep in mind, the firm is always going to be acting as a dual agent if two of their agents are going to be under contract together. And thus, any managing brokers who supervise are also technically acting as dual agents on their behalf. So when 2024 comes around, and I encourage everybody to even do this before that, you have to establish either a buyer relationship, a seller relationship, a limited dual agency relationship, because there will no longer be this implied relationship that we've been used to so far. They have bullet pointed down very, very small, thank goodness, the broker duties. Now, these duties are taking the place of the buyer column and the seller column, because these duties apply to whoever you represent, whether it be buyer or seller. So you'll have the duty of loyalty. You'll have to still disclose timely any conflicts of interest, advise them to seek expert advice on all matters outside of your scope. This is a very, very important one. And if you find yourself in a transaction where anything comes up that is beyond your scope, at some point in the transaction, please just put this right into an email, CCing either your brokerment file, your transaction coordinator, or just the firm that you were advising them to seek expert advice or advising them to seek an attorney on this issue. We want to kind of take that off our shoulders. It is not our job to do that, and it is not our right to do that. Also, of course, as before, we cannot disclose anything confidential about the person we represent. And then finally, we have to do everything in good faith for the client we represent. Finding a buyer for the property, everything in good faith. I'm just going to keep it bullet pointed for there. Now, the relationships we create. We have a written service agreement, like I said. This is going to be the buyer's agency, the listing agreement. It does have an end date, right? So it's either going to end when you have satisfied everything you need to satisfy, you've gone under contract and you've closed, or it's expired the time frame that it's written down on there. Now, I haven't pulled it up because it's not for this week, but our buyer's agency agreements are actually going to be shortened quite a bit in the time that it's defaulted to. And hopefully that will help with some conversations that you may have in getting that signed. I did pull it up. I did not pull up the entire thing, but this is the front page of what the listing agreement is going to look like in January. The listing agreement is going to be updated with more agency disclosures. And this obviously is going to be required to create your agency relationship. Another thing they've done to make it kind of seamless and fluid is to lay it out in the way that you would talk to your client. For instance, the first thing you're going to do is explain about who you are, explain about the agency relationship you have with them. Thus, they are adding in, handing out the pamphlet in the beginning of this form. And then it kind of just goes on about, in the direction of which you have normal conversation. Same with buyer broker agreement. Like I said, though, they did shorten the time frame. It is now 60 days to default versus, I think it was 4 months before. But again, come 2024, you're going to have to establish this relationship. It will not be implied. And we're going to have to keep all of these, all of these agreements on file. The red line items we will go over in another time with another class. And then coming up in the next 30 days is going to be, the how to talk to your clients about this, different ways we can approach these. All right, so the duties to all party are also the same, but definitely bullet pointed a little bit easier to understand. We all have to exercise reasonable skill and care. We have to be honest. And we all know that we need to present all written offers, written notices, written communication from, that is to one party from another. So this includes if you are texted an offer request. Say somebody texts you wanting to know if your client would be willing to, reduce the price $1,000 if something happened. That's the kind of communication that we should be relaying to our clients. It is technically written communication. It is not a written offer to purchase, but all of those conversations back and forth are considered offers. So anytime you have communication that goes to your client through another agent, please make sure you are relaying that to your client. We all know that we have to disclose material facts. These are facts that are actually just not readily available. So, if you have something like a broken window that's right there by the front door, if your client forgets to disclose there's a broken window, it is technically that it is something that's right there, readily available. We do have disclosures and material facts that are known through title reports. Anytime you deliver a title report, you're delivering available information. So we can go into more detail with that when we talk about the Form 17 and what to or not to disclose. Also, we need to account for any money. Thank goodness we don't collect the money. I think everybody in the Madrona group is on the same page with the money, earnest money going directly to whoever that closing agent is or whoever the party is who is holding the money. If you happen to get earnest money, make sure you're actually receipting it out with the proper form. There's a Northwest MLS form designed specifically to receive earnest money and record that. We are responsible once it hits our hands. As with that, we are also responsible for keys and lock boxes. So when it comes to exchanging anything like that, we are going to have to make sure that we're tracking it very well. And then obviously when we are writing up contracts, we want to make sure that we're disclosing which broker represents which party. Number 8 is actually something that's been added to because we're trying to be as transparent as possible. Every one of our contracts is going to have to show compensation that's offered and where it's going. This may create a lot of conversation later, and I am definitely open to talking about that. But the idea is because compensation was not something that was readily spoken about. We are trying to, as an industry, be as transparent as possible and get all that information out to everybody involved in the sale. All right, I already did that one. Dual agents. So when you choose a dual agency, they've actually renamed it to a limited dual agent. And it's limited because there are more limitations to the duties that you can provide. So if you're going to be a dual agent, make sure you know what you can and cannot say. Basically, what you're doing is you're acting as a mediator. So you can't take action against one party and you can't be beneficial towards another party. You still have to keep the communication going and not disclose anything that would adversely affect them. Act in good faith. You are essentially only a mediator. And in doing this, we need to also make sure our clients understand that if that's the role we take, then we can't give them advice on prices to offer, terms to come back with. We are just facilitating the conversation. So think about that and practice how you would say that to your client. Also, if you ever find yourself in that situation and you have a sale that, say, needs an inspection contingency, I would highly consider maybe referring out one of the to a buyer agent, or at least somebody who can help kind of negotiate the inspection responses and kind of keep you out of the picture when it comes to information that you don't want to know. Compensation, it does briefly talk about compensation. This is in direct response to the lawsuit. We don't want to be saying things like, oh, the seller pays for me, you don't pay anything, buyer. We want to make it abundantly clear that each party is responsible for their own agent's fee. And it may be possible that in our market, a seller might be willing to either pay some of that or pay all of that. But we are going to be holding sellers accountable for paying their agents, and we're going to be holding buyers accountable for paying their agents as well. We have to have clarity on this. This is what we are going to role play a little bit. Make sure you just use your words very, very carefully. And make sure if you are a commercial agent that you are including a compensation disclosure in your transactions as well. It does speak briefly about short sales, but in a nutshell, it just lets the seller know that their obligation to pay doesn't go away just because their home is in short sale. So that is the entire buyer's agency agreement wrapped up into one nice little 4-page document. But the idea behind this is knowing who you represent. So think about these situations and think about what your duties are and how you would respond. So here's a situation. You're the listing broker. A buyer comes to your open house and talks to you about their love for the house. They tell you they want to put an offer on it for $750, but they would go as high as $775. So what duties do you owe to that buyer? And what duties do you owe to your seller? So to that buyer, what you should have owed them was the delivery of the agency law pamphlet. You would owe them the honesty of telling them who you represent and the disclosure of who you represent. The honesty would be what it means when you represent that seller. So there should never be a situation where a buyer unknowingly confides in you when you don't have to remain confidential. Make sure you're disclosing who you represent and what you are and are not allowed to say to them. To that seller for whom you represent, you do owe the duty of loyalty. So you will find yourself in a situation now where you know things and you'll have to navigate how to get through that. Another situation, you go to a listing appointment and the potential seller reveals some confidential things to you, such as a desperate reason for selling. At the end of the appointment, you guys part ways And then you see a week later that it's listed with another agent. Happily, you find a buyer. So what are your duties now to that seller who you had the listing appointment with? And what about that buyer who you now represent for the sale? I am going to assume also that if you represent a buyer, you're going to have your buyer's agency agreement signed. So the answer is, to the seller, you technically owe nothing because you did not have an agency relationship. But again, you should have made that clear and handed out the agency law pamphlet at your listing appointment. And to the buyer, you must be true. You now have an agency relationship with your buyer, so you have to be loyal to them. You cannot do anything to their detriment, and you need to refer back to your duties on the agency law pamphlet for the client you represent. So are you ready for 2024? We need to make sure every person we discuss real estate is aware of our agency relationship. We will need to provide them the agency law pamphlet with all of our brokerage services we provide. So remember that long list of services. So create a system to track this for the firm file. Some agents actually initial the first page. I think that we need to make sure with the new things that are coming to us, that is, we need to make sure we're actually able to prove some of these things in our future. Our once blurred lines of the implied relationships are ending in 2024, and there will no longer be an assumed buyer's agent. They're calling it a broker service agreement. So without that broker service agreement, there will be no agency relationship. And without the agency relationship, there will be no legal way to get compensated as a broker. So start getting into the habit right now of making this part of your regular conversation so you can stay ahead of the curve. All right, thank you very much.